Very happy to introduce Jonas-Sébastien Beaudry, who will be speaking on what is disability, theoretical strategies to define a contested concept. After Jonas Beaudry, we will have Michael Bach commenting. I'll first introduce Jonas Beaudry and then Michael Bach, and then we'll get going as usual. So Jonas-Sébastien Beaudry has a doctorate from Oxford, an LLM from Harvard, and an LLB and a BCL from a good university, McGill University. He's also a member of the Barreau de Quebec. He teaches and researches in disability and health law, disability studies, legal theory, and human rights. Professor Beaudry clerked under Justice Marie Deschamps at the Supreme Court of Canada, served also at the International Court of Justice, worked for 15 months in the Inter-American human rights system in Argentina and Costa Rica, from which resulted a book, Dialogue démocratique en Amérique latine, where he examined how freedom of expression could secure access to the public sphere in a Latin American context. He held positions at the Université du Québec in Montréal, San Francisco State University, St. Catherine's College in Oxford, in addition to the things I already mentioned. He was also, not to forget, for 3 years an assistant professor of law at the UBC Faculty of Law. His PhD, interesting to mention, can social contract theory fully account for the moral status of profoundly mentally disabled people? And I would add that I particularly enjoyed also reading Professor Beaudry's paper in a special issue of the Supreme Court Law Review, where he discussed recently the social dimensions of autonomy in the context of the medical assistance in dying debate, which I thought was, in the context of a lot of it, which has been published, a very, very thoughtful piece. So maybe he'll make references to that debate as well. So following Jonas Beaudry's presentation, Michael Bach will be commenting. Michael Bach, who has for over 25 years undertaken research and development in Canada and internationally on ways to advance the full inclusion and human rights of persons with disabilities. His research and publications cover disability theory, policy and practice, and a range of areas, including education, employment, and funding and delivery of community-based services. His particular area of expertise is legal capacity of people with intellectual disabilities. Michael holds a PhD in sociology and equity studies from the University of Toronto's Ontario Institute for Studies in Education, with a dissertation focusing on developing more inclusive theory of personhood, in which to challenge the usual equation between intellectual disability and legal incapacity. He is currently an Open Societies Foundation Fellow, with which he continues his international comparative research on the right to legal capacity for people with significant intellectual and cognitive disabilities. And both actually are advisors to the Vulnerable Person Standard. Michael is certainly one of the founders of the Vulnerable Person Standard, an advocacy organization which has been very active in the context of medical assistance and dying. Jonas. One quick thing, I will distribute a present list as well, particularly for the students who take this as a course. Please fill in your name. For the others, we'd like to know, as many of you know, we'd like to know who is attending the seminar, so please fill in your name and just your affiliations. Thanks.
Thank you. Thank you very much, Hugo, for this introduction. I'm quite happy to be here. So today, and I apologize for a cold, so my voice I'll do as well as I can with the voice that I have now. So today I want to ask the question, what is disability? And look at how theorists, activists, policymakers can handle the fact that disability can mean many different things. Now, the central case of disability seems deceptively obvious in popular culture when we think of a severe permanent impairment, such as tetraplegia or blindness. It's nonetheless impossible for policymakers and philosophers to agree on a single definition. Disability is, I quote, a complex dialectic of biological, psychological, cultural, and socio-political factors. And because of that conceptual breadth, some scholars and institutions like the World Health Organization have defined disability as an umbrella term, covering many facets of a complex phenomenon. But it's not clear if we're talking about a single thing with many facets, or different phenomena altogether. And when an umbrella concept tries to capture all the facets within one definition, it's not clear which facets is given priority over others or which one causes the others. We all know what a disabled person is, Tom Shakespeare writes. It is a common sense category, much as woman or black person or homosexual. These are all words we use with confidence. Yet, a closer inspection reveals that those categories, disability, race, gender, sexual orientation, taken to be natural features of certain individuals, are at least partially socially constructed. And they may refer to relations between people or expectations imposed on people rather than to a kind of people. For instance, the idea of being disabled may be born out of expectations of being a productive worker in certain settings. So if that's the case, disability would be defined in function of an understanding of labor. Mark Oliver thinks of it in this way, for instance. Alternatively, people with disabilities may be those whose capacities just don't fit a certain theory of justice. For instance, people with intellectual disabilities or severe disabilities may lack what it takes to be a contractor within social contract theories like John Rawls's. Or, rather than being identified as a minority, rather than serving as a concept to identify a group, to single it out, the concept of disability may be used as a critical tool by activists looking for disabling contexts rather than disabled people, or by theorists challenging assumptions about normalcy, ability, productivity, reciprocity, and so on. So disability studies has the potential to pull the thread of the greater fabric of our social imaginary and make us wonder about what justice, beauty, morality, social arrangements, the law could involve if we did not treat different bodies as outliers. As Lysia's speech on a disabled aging tradesman pleading before the Council of Athens to keep his disability pension suggests, how we define disability has long had concrete repercussions on people's lives. Theoretical models of disability can do concrete harm or good. For instance, they can contribute to segregating people with disabilities, or they can empower them, for instance, by making claims through equality rights. The paper circulated draws our attention on what it is that policymakers, legislators, judges, activists, medical and legal practitioners, and scholars from different fields, what it is that they're doing when they are defining disability. It invites us to look at not just how they define one particular aspect of disability, but also at how salient they make this aspect within the experience of disability as a whole. It invites us to ask whether their way of looking at disability implies or suggests that other ways of looking at it are not valid or less important, or valid but not worth legislative attention, or worth legislative attention but not charter protection, or worth charter protection but just insofar as it means unequal access to care that other people get, but not access to a good that only certain people with disabilities would need. It invites us to try to identify the implicit theory or model of disability at work, and perhaps to live with the discomfort that there may be many of them that are coexisting. How we define disability in cases, laws, pop culture, etc., will typically create assumptions about what causes responsibility, what causes this phenomenon, what causes this disability, whose problem it is, where it is located, assumptions about how we should respond to it, and the responsibility for giving this response. So within the medical model, we have a narrative. Within the social model, we have a different one. And there are many others. Many other models of disability. And so I say they're typically related because causality and responsibility are not necessarily connected. So someone could adopt the medical or rehabilitation model of disability, and meaning that they would be persuaded that disability is an individual medical matter, and still assume that the responsibility to help that personal individual problem lies with the state, like it's the case for illnesses in Canada, for instance. But it's still tempting to systematically correlate causality on the one hand, so what caused the disability, so an impairment in your body or society, and responsibility on the other, who should attend problems related to a disability. But it may too quickly assume that the fault, the blame, or the responsibility must lie with the cause of the problem, the individual or society, for instance. So of course that can be the case. If someone, say, injures you so badly that you become blind, it's likely not only their fault, causally speaking, that you have become blind, but they also be blamed for it, and the responsibility, it seems, can fall on their shoulders fairly. But if your assaulter is poor and cannot support you in your blindness, we would still think that the state should offer you some kind of support, even though the state did not directly harm you. On the other hand, there are certainly cases where you will want to make the case that causality implies responsibility, when you need those narrative. Indeed, the social model of disability, I'll talk a bit about it in a moment, promotes the rhetorically powerful idea that we are disabled by society, not by our bodies. And it assumes that responsibility, therefore, is to be attributed to society, which is the culprit. So, this project began with being asked to write about what disability is. The concept of disability can be used to accomplish so much work, political work, legal work, cultural, psychological, and theoretical work, beneficial or harmful work, that cataloging all that work through some kind of a historical survey would be too monumental. So to maintain a degree of generality while asking a specific question, I retreated to the realm of meta-theory. So instead of asking what is disability, I asked myself, how do we handle the fact that there are so many competing answers to that question? So I started looking at how conceptions or models of disability found anywhere, philosophy, laws, statutes, case law, pop culture, and so on, how they dealt with the concepts polysemy. That is, I categorize them as different kinds of philosophical strategies to handle the fact that disabilities has various meanings that cannot be reduced to one another, meaning it's a polysemic concept. Doubtless the notion of disability poses other problem than polysemy, but the polysemic nature of disability, its very messiness, is a feature worth reflecting on as a challenge faced both by philosophers of this highly indeterminate, if not essentially contested concept. So the polysemy of disability is an issue with practical consequences. Jerome Bickenbach reports that countless definitions identifying different people and different needs govern differently purposed disability policies. So that there are many policies that conceive of disabilities differently. And Jerome Bickenbach asks if this plurality of meaning is a sign of incoherence that we should remedy, and something inevitable, just something we have to live with, or perhaps something appropriate and perfectly acceptable. Barbara Altman also points out that the polysemy of the concept of disability can have lamentable repercussions on the welfare of disabled people, for instance, if it prevents them from benefiting from certain kind of benefits of support. So I suggest that polysemy is an interesting feature of disability and one that may never go away. It's not surprising, given that disability is a multifaceted, evolving cultural object that is commonly understood to refer to many different things. What is surprising is that philosophers would assume that this polysemy is only a contingent, uninteresting feature of that concept of disability, a kind of cultural mess that they must clean up. And that's a problem because sometimes disability theorists disagree, but they're overlooking the fact that they're talking about different phenomena. So impairments instead of oppression, care instead of justice, legal instead of extra-legal obligations, and so on. So some of those disagreements might be more productively handled or articulated as disagreements, not about what disability really is, like a kind of war to get to own the definition, but instead as disagreements about how to handle the fact that there's no single answer to that question. That is, disagreements about how to handle the polysemy of disability. So we need strategies to do that. There are strategies to do that. And the 5 theoretical strategies that I examined in my paper to do that define disability in ways that deny, transcend, or embrace this polysemy. So it includes, first, determinate accounts that are either reductionist or mixed. Then second-order accounts that are open-ended with regard to reference or value. So that means that those second-order accounts make room for disability to mean different things, to refer to different phenomena like oppression, illness, and so on, and to be valued differently, be a good thing, a bad thing, a neutral thing. But those accounts still work according to some stable rules to identify what counts as a disability. And third, more radically open-ended accounts. So no account being flawless, the question may boil down to determining which flaw we think is the least harmful in this or that situation. So what does a determinate, so I'll go through the 3 of them. So what does a determinate reductionist model of disability look like? So prime examples of reductionist accounts are the medical and the social models, which define disability exclusively in terms of biological dysfunctions or social oppression, respectively. Medical models of disability hold that disability is a private issue, exclusively or primarily caused by biological impairments. By contrast, social models claim that disability is socially created through a variety of obstacles that prevent people with impairments from having equal opportunities, access to public spaces and institutional resources, and so on. The contrast between those models constitute a seminal dichotomy in disability studies. The more exclusivist an account is, the more it says disability is this and not anything else, the easier it is to attack. A definition that categorically excludes any biological or social or economic or legal or experiential influences from the purview of the concept of disability is giving itself the almost unsurmountable task of demonstrating that all those other facets of disabilities are morally or descriptively misguided or trivial or pointless, wrong. So perhaps because of these issues, it's a challenge to find an explicit philosophical defense of a reductionist medical model. Someone would say disability are really just only a biological impairment. However, the medical model remains culturally influential, and its lack of formal defense isn't surprising. It reflects the ideological and invisible status quo that fuels the popular ableist view that disabilities are private medical tragedies. So the best parry to an anti-reductionist attack is essentially to give in, I think, and narrow one's claims down to specific dimensions of disability. So say I'm just talking about oppression, like Mike Oliver, for instance, did that when his reductionism was criticized. He said, well, I'm just talking about oppression. If you want to develop a sociology of impairment, you can, just don't call that disability. So the main advantage of a reductionist view nonetheless seems to be that it targets specific issue, medical care or social oppression, so it draws policy makers' attention to them. It's a powerful language for activists. It is simpler to carry a message through. Critics of the social model answer that its focus on oppression fails to attend many other aspects of disability, like the body and impairments and subjectively experienced phenomena by people with disabilities, and even that such understanding of disability would be used in the control and constitution of a disabled subject. So let's look at mixed model of disabilities now. Those were the reductionist ones, the one that say disability is one thing. Now let's look at those that attempt to pool all of those neglected facets together. So, but as we do so, let's remember that even if mixed model or multifactorial models claim, even as they claim to not grant more importance to that or that aspect of disability, we may still detect a reductionist drive when we see implicit hierarchies between the components, making this model look like a Russian nesting doll than the teddy bear before, because a disability model may well encompass both impairment and disability, for instance, impairment and social oppression, and both scientifically tested and socially constructed elements. But theorists often place one of those sets at the heart of the doll in terms of causality, responsibility, ontological explanation of what disability is, so that, and if other people invert the doll's order of imbrication, is suspected of being either unrealistically politicized or overly medicalized, depending on which reductionist tendency they have. So mixed or multifactorial models of disability identify more than one cause of disability or incorporate distinct dimensions of disability within a single definition. So whereas reductionist model holds that disability means A or B or C, a mixed model holds that disability means A and B or A and C or A and B and C and so on, wherein A, B, C, etc. denote different dimensions or reference, things you refer to, phenomena, different dimensions or reference of disability. Mixed models typically define disability as the product of an interaction between physical or psychological facts and social ones. The overall gravity of a disability may then be measured by a contextual benchmark, for instance by functional limitations, although its treatment may be compartmentalized, for instance by offering physiotherapeutic treatment in one case, or a reasonable accommodation in the workplace, or a lawsuit in the other. Sociologist Saad Nagy's influential mixed model of disability was one of the first to address the confused multiplicity of concepts falling under the umbrella idea of disability. His publications on disability span over 4 decades, and his latest definition of disability loosens its connection with impairment while incorporating the insight of the social model, which has become increasingly mainstream. Another famous example of a mixed model is the WHO's the World Health Organization's biopsychosocial model. The very title shows you biopsychosocial, so they're trying to bring everything in. That's the hallmark of a multifactorial or mixed model. Another strand of multifactorial accounts, of mixed account of disability, has suggested that disability is a scalar thing. It comes by degree. It is a universal condition that we all have that comes by degree, in the sense that all human beings, you and I, everybody, are at risk of some degree of disability over the course of their lives, of our lives. Irving Zola's influential model of such that is connected to the ideals of universal design is a kind of mixed model, since it recognizes that disability is a function of the fit between any impairment in the larger social environment. Okay, so multifactorial models do justice. So I'm criticizing and praising each of them, right? So those models, the good thing is that they do justice to the complexity of disability-related issues. But like reductionist models, they require that claimants meet determinate criteria before being considered as disabled. As a result, certain claims for justice may be denied for reasons that appear formalistic, arbitrary, or substantially misguided. So a striking illustration of the humiliation and attrition that people with disabilities and their families face, and as the result of an often stilted evaluative grid of what criteria you must meet to receive some kind of support or help, is Ken Loach's movie from 2016, I, Daniel Blake, which depicts disability claimants tormented by Kafkaesque bureaucracy. I wanted to show a bit here, but I just highly recommend you watch the whole movie on your own. I, Daniel Blake. Analyzing legal successes and failures, Judith Mossoff, a legal scholar, has noted that some disabilities rate lower on a hierarchy of legitimacy. So for instance, people claiming a disabled status due to chronic fatigue or pain, temporary or invisible disabilities, mental illness, addictions, and so on might be suspected to fake their condition. Under the Canada Pension Plan, a person must have a severe and prolonged mental or physical disability to be deemed disabled. And those criteria are further narrowed in the text of the law. So Alan Granovsky's temporary intermittent disability prevented him from working sufficiently to access those Canada Pension Plans provision that would offer him some kind of tax exemptions that offered greater tax exemptions to people who have a severe disability. In the case Granovsky in Canada, he challenged that definition of disability that excluded him. The Supreme Court of Canada decided, however, that the legislation was not discriminatory, as drawing lines is an unavoidable feature of the CPP, and because Parliament was entitled to not provide benefits to, I quote, more fortunate people who don't have a permanent disability. So critics of determinate models may agree that under or over-inclusiveness can be perpetually corrected until we get it right, until we don't exclude some people it seems we should include. But they argue that a commitment to fixity of criteria, in spite of its pragmatic virtues, namely the law likes bright lines, need bright lines, but they argue that the fixity of criteria is still conceptually wrong-headed. Descriptively, critics would say, it wouldn't do justice to the extraordinary variety of the evolving cultural nature of disability. Moreover, even though a determinate model may be more or less successful at enabling the identification of almost all cases of disability, it's not clear we should endorse a framework that will still exclude those peripheral cases. Finally, determinate models might fail even on their own terms, as point-based policies construct disability instead of merely capturing it. So according to some critics of these models, they invite people to constitute themselves as disabled subjects. They create disability and abnormality through all those governmental forms that they have to fill, that they have to behave in a certain way to become that disabled subject that the government wants them to be in order to receive some kind of support. So those critics are, the main proponent of those kinds of critics that interest you is Shelley Tremaine. Determinate models' inherent lack of flexibility risks excluding some people and normalizing others, thus becoming tools at the service of ideologies rather than being at the service of the likes of Daniel Blake or Alan Granovsky. So the main takeaway is that the virtue of determinate models is that they lead to a stable, uniform, predictable, and efficacious basis for disability claims, if you fit in. Lawmakers like clear criteria. The problem is that those criteria may lack flexibility to accommodate unusual, new, peripheral, or otherwise neglected disability-related claims that are nonetheless morally compelling and that should actually have been considered. So let's move to the second order accounts of disability. So instead of giving definitions of disabilities, those accounts, the way they deal with disagreement about what it is so there are strategies to give rules to decide what counts as a disability. So consider, for instance, Savulescu and Kahan's welfarist account of disability as a biological or psychological state. So they say, so if you ask them what a disability is, they won't point out to particular physical conditions. They say whatever falls within this definition, the following definition, is a disability. So a biological or psychological state that makes it more likely that the person's life will get worse in terms of his or her own well-being in a given set of social and environmental circumstances. So that's one example. Another example is Tom Koch's claim that Tom Shakespeare, a disability activist who has achondroplasia, is not disabled by his achondroplasia, but rather by his decreased professional influence within part of the disability communities because of his controversial views. So those two examples clash with our ordinary intuitions about disability. Kahan and Savulescu's account implies that being gay in a homophobic society or black in the antebellum American South would be disabilities. And Koch's suggestion is even more radical. It altogether detaches the concept of disability from the body. And it makes it a state of affair that simply undermines an individual's power or ascendancy. But that may just mean that some open-ended accounts are not convincing, not that they can never be. Perhaps one more promising kind of open-ended account focuses on processes, offering a mechanism to decide the rules according to which disability will be identified and or dealt with. So that sort of accounts provide rules about rules. So it has the virtue of avoiding disagreements by developing agreement on a way to handle disagreements. So for instance, Elizabeth Barnes has recently argued in her book, The Minority Body, which I recommend, what counts as a disability can be determined according to rules decided by members of the disability rights movement. So with the proviso that the content of those rules must rely on judgments of solidarity and that their normative orientation relies on the theory of justice. So I cannot go in any depth into her theory, but the idea is that the disability rights movement has a say, but it doesn't get to say this or that is a disability. Rather, they get to say those are the rules according to which it seems fair to decide whatever should count as a disability and how to treat it. This particular account, like any account, has problems of its own, namely within the disability rights movement itself, certain disabilities have been historically marginalized, such as intellectual disabilities or mental illnesses. Disability accounts may also allow for the value of disability to be open-ended. That is, disability are not necessarily good or bad, it depends. So there is intuitive appeal to such a perspective because a mild intellectual disability and being in a wheelchair have very different repercussions if you live in a pre-industrial farming era or in a society trading knowledge as a valuable currency. Proponents of this view have argued that people who always assume disability is bad should be open to the idea that it could be a blessing in some circumstances, and conversely, even those embracing disability pride should not deny at all times that sometimes disability is a bad thing. A worry, so that's the idea behind being open-ended with regard to value. A worry one might still have with these open-ended accounts is that they're still not inclusive enough. So some radically open-ended accounts of disability, and then you start seeing disability in text appearing between quotes because it's always constructed or spelled in original ways. So those more radically open-ended accounts challenge the ingrained tendency for disability activists and scholars to claim a clear set of identities as disabled people. So while second-order accounts of disability avoid settling on a stable definition of disability, and instead look for a stable method or procedure to get to that definition, the radically open-ended accounts resist any notion of determinacy, substantive or procedural. Radical open-ended accounts do not tie the meaning of disability to any determinate content. They also challenge various uses of the notion of disability that they suspect to be complicit with in comforting an able-disabled dichotomy. So it sort of follows other social movement waves, and first focusing on a particular identity that is trying to define itself differently, and then later scholarly waves can come in and start problematizing that very identity in partaking of some greater problem. So its proponent concede that medical, social, or civil rights model of disability can helpfully choreograph the pursuit of specific goals to improve the well-being of people with disabilities, while insisting that these models will not challenge the issues at the heart of the problem. Those include the fundamental binary of disabled, non-disabled, the psychosocial imaginary that disavows morphological imperfections, to quote Sheldrick, the powerful negative affective responses felt toward differences, and the meta-historical narratives that exclude important dimensions of disabled people's lives and their knowledge. So those powerful vectors undermining the well-being of people with disabilities can only be challenged by radically reconfiguring the meaning of disability in order to disrupt the whole nature of the relationship between differently embodied subjects. Okay, so I'll leave it at that for the radical criticism. And critics of this very open-ended approach would say that agreeing to disagree doesn't move a philosophical discussion very far, and conceptual breadth that seems freeing also comes at the cost of some kind of sterility when we try to engage in concrete discussion. The strongest criticism of radically open-ended approaches comes, as one would expect, from the reductionist, the other end of the spectrum. In particular, first-wave disability theorists have strongly criticized the political efficacy of those second waves, those more radically open-ended perspectives. They argue that the focus on subjective experiences and deconstructing categories of disabilities and disability has distracted from the all-important concrete emancipatory goals advocated by disability rights movement. However, one may reply that open-ended approaches can create avenues for new kind of emancipatory self-understandings. So the matter is complex, because even if we agree with the position that disability research should always be partisan and should be judged in terms of its capacity to facilitate the empowerment of people with disabilities, empowerment may be understood in very different ways. An open-ended outlook on disability can also be criticized for squandering hard-earned political capital related to the term of disability if you start criticizing that disabled identity connected with rights. Postmodern and post-structuralist writers are well aware that disabled activists will struggle with radically open-ended models. They're notably complicated and difficult to comprehend without an understanding of their philosophical underpinnings. Well, that's just up to those thinkers to be clear in translating their work. But a more substantial problem is that some accounts of disability can simply not be operationalized within existing legal and political frameworks because they challenge some of the basic liberal assumptions, the language of rights and individualism that activists work with. So to sum up what I do in the paper that was circulated, I take the polysemy of disability seriously, and I categorize and examine the main philosophical strategies from reductionism to radical open-endedness to manage the semantic breadth of the term disability in descriptively or normatively helpful ways. And I present some of the strengths and weaknesses of each view, and I suggest that they may be deployed simultaneously if they don't inevitably clash. So I wanted to talk a little bit about, do I have 5 minutes left?
Yeah.
Okay. So how those ideas translate in practice. So the goal would be to find those different determinate, reductionist, mixed, second order or open-ended tendencies that I described. So to find those tendencies in different policy documents like statutes or judicial decisions, and to see whether and how far this or that tendency comes with the advantages or disadvantages that I've been listing. And my contention is that there is no easy answer. There will always be something that will be sacrificed. And so it's up to us to look at each situation. But we can start challenging situations where it seems to yield more harm than benefits. So, for instance, if we want to look for an open-ended tendency in our law, one of the questions ask this to rethink how the law operates. So, do you think there's a way to rethink? It's Hartley Zucker who wrote, do you think there's a way to rethink how the law operates in relation to disability that would allow to interact better with more open-ended conception? So, as it happens, there is the closest our Supreme Court came to an open-ended model was the Mercier case in 2000. It provides us with a platform to begin discussing what a post-identity approach of disability might look like in legal terms. So in that case, 3 individuals complained to the Quebec Human Rights Commission for having been discriminated against on the basis of their disability. Mrs. Mercier and Mr. Jean-Marc Hamon had spinal cord anomalies and were not hired by municipal bodies to work. Another municipality refused to hire Mr. Palmerino Troilo, the 3rd appellant in Mercier, because he had Crohn's disease. So the case raised the question of whether the complainants were disabled in a legal sense, just to fall under the Human Rights Code, considering they were all asymptomatic. The Supreme Court of Canada, recognizing that the nature of discrimination is, I quote, often subjective and may be based on perception and myths just as much as on actual physical limitations, agreed to, so they accepted, they detached disability from impairment. The Supreme Court did not, however, endorse a general stigma-based conception of disability that would completely detach it from the idea of the body. They still have to be body-related. I'll leave it at that because I want to say a bit about something else. So that discrimination model of disability came close to agreeing with David Wasserman's plea for a demedicalized interpretation of disability under the ADA, the American Disability Act. Wasserman argues that protection against disability discrimination should extend to any disfavored physical and mental variation. If the goal of human rights legislation is to protect people who are stigmatized and disadvantaged, then it would seem counterproductive to ignore how disabling habits of thought and social practices function. Wasserman's stigma-based approach to disability, or Mercier's, the case, Justice Leroux-Dubé's discrimination model of disability, would turn our attention on how and why stigma function and invite analysis of a history of negative affective responses toward abnormal bodies. So open-ended accounts have the virtue of allowing legal actors who ask whether and to what extent the notion of disability should be extended to capture those not yet theorized or politically recognized social ills. So for instance, someone who is disfigured by neurofibromatosis, or someone who is disfigured by fire, someone whose face is heavily tattooed and whose nose, ears, eyes, lips, etc. are pierced with a great number of rings, and someone who wakes up from a coma to discover that they were involuntarily tattooed and pierced in the same way. So many mainstream criteria used to evaluate a discrimination claim that we would use to distinguish those cases, such as medically recognized impairments, the presence of or absence of choice, functional limitations or not, would fail to detect the lookism, so the bias about abnormal looks that unifies all 4 cases. On the other hand, whenever an approach to disability becomes too open-ended, then it would deprive courts from clear, easily supported criteria to establish disability discrimination. But there's also a pressure to distinguish who the so-called truly disabled are, but I might come back to that if we have time. Yeah, I think so. I just wanted to say that. So just to show how concretely present they are in judicial thinking, Justice Opinka wrote in Eaton, the principal object of certain of the prohibited grounds is the elimination of discrimination by the attribution of untrue characteristics based on stereotypical attitudes. In the case of disability, it's not the only thing. There are also so-called true characteristics of a group. And when Sapinka wrote this in 1997, he didn't mean to excuse the legislator from intervening when people with disability would be disadvantaged or suffer exclusion because of something physical, like an impairment in them. On the contrary, he says society then has a duty to accommodate them. But in saying that, Justice Sapinka was already nodding toward a model, was nonetheless supposing a certain cause or origin for social exclusion, a biological one, as ultimately nesting like the smallest doll within a Russian doll, within the greater problem of social inclusion. And that thinking was picked up by Justice Bini and Granovsky, who this time did not only dissociate between prejudices on the one hand and the so-called actual or true bodily anomaly on the other. Justice Bini also offered a rationale to excuse the legislator in the latter case. by saying that the Charter is not a magic wand that can eliminate physical or mental impairments, nor can it alleviate or eliminate the functional limitations truly created by the impairment. And here, the same logic was used to minimize the duty to help. Okay, so I could say some more about those cases, but I'm out of time. But I just want to show how real the impact of selecting a model implicitly or explicitly can be in judicial thinking. Thanks.
First of all, Jonas, thank you very much for your incredibly incisive paper about the categories that we deploy in cultural discourse, political discourse, legal discourse around disability and revealing their underlying structures. I speak here I want to speak here in my comments from the perspective of someone who's been engaged in the disability rights movement, involved in litigation and social movement building work for many years. To think about how this analysis of the categories that we use, this critique of the categories that we use, inform our work and make sense of what we do. Because we live these struggles all the time in our politics. I also want to just acknowledge Jonas for this really brilliant paper that's been published in the Supreme Court of Canada Law Journal, the special issue, for revealing challenging the very thin notion of liberal autonomy when it comes to disability, for its disappearance of the social conditions that make autonomy possible for people. So I encourage you to read that paper as well. So Jonas opens with a question: how do we handle the fact of this polysemy of competing answers to the question of what is disability? And he encourages us to be conscious about the multiplicity of those answers. And I think that in fact that's the potential of that's the potential of this scope that he's laying out for us. It's not to choose a true account, the one true account, or the best account of disability, because we strategically deploy all of those accounts depending on the context that we're in. And so I think it's a question not so much of what is the truest account, the most ontologically kind of valid account of disability, but it's, for me, from where I sit, it's what accounts of disability are best fit for purpose, are best suited to purpose. And it's a question about what are the purposes that we're pursuing. And because accounts of disability are deployed to achieve certain ends. They're deployed to achieve certain objectives of justice. They're deployed sometimes unconsciously. Hopefully they're deployed strategically. And the importance of Jonas's work is to help us to be conscious about the accounts of disability that we're deploying, but I think also to be conscious of the objectives we're pursuing with those accounts. And while I think, Jonas, you sort of situate your work and your engagement kind of in the academy, in this competition between philosophers of disability and the law of disability, and I think sometimes you point to some of the conflicts between disability activists. And I think at the core of some of our challenges in the disability rights movement is that we are dealing with competing accounts of disability without being fully conscious of it. And without being fully conscious of the objectives to which we're working. I want to give you a couple of examples. Trudeau mentioned the MAID debate in Canada, medical assistance in dying. There isn't a universal, singular disability rights perspective on this debate. In fact, disability rights activists are competing with each other in the court. They competed with each other in Carter, the Carter decision, and we're competing right now in a case out of British Columbia and in the Truchon case that's just started in Quebec. And I want to go into this because I think it reveals, I mean, in reading Jonas's paper, it helped me to understand more clearly what the core tension, and it's a bitterly fought tension that's going on in the disability rights movement right now. Right, so Carter is launched by a couple of plaintiffs who experienced a loss of dignity in their lives because of impairments. They brought forward very much a biomedical account of disability, and they said, because I have these impairments, it's causing me an indignity, and therefore my right to autonomy and liberty in Canadian society under Section 7 of the Charter is undermined if I can't exercise my autonomy in how I'm going to die. And as I become, and some of the additional plaintiffs that have joined that and other cases are, I don't want to be at a place, I shouldn't have, there may be a time when I cannot take my own life. I'll become so physically disabled, so impaired that I can't take my own life. That undermines not only my Section 7 rights, but my equality rights. My equality as a person with a disability is going to be undermined because I'm going to be so impaired that I can't take my own life. Now, that equality argument didn't end up at the Supreme Court, but at the BC Supreme Court, it was very much present. And Justice Smith provided an answer to that. She agreed with that account. People's equality is undermined if they can't take their own, if they lose the physical ability to take their own lives. This account, so this very impairment-focused account of disability motivated the plaintiffs and in fact shaped some of the reason. The disability rights movement, the part of the movement that I'm associated with, our intervention was, whoa, wait just a minute. And we drew on Mercier and the account of disability that it's about stigma, and to the extent that we live in a society in which an impairment can be associated with a justification to terminate a life, you're sending a message about disability. And you're creating a culture and a cultural discourse in which my differences, whatever they are, could come to be equated with a reason to terminate a life. So there isn't one account of disability that is truer than another. There isn't one account of disability that the disability rights movement is utilizing. We use biomedical accounts of disability when it suits certain purposes, and we use the stigma-based approach to disability when it suits other purposes. So the question is, what is the purpose that we're after? And what does justice and inclusion actually require? And there isn't one answer to this, I guess is my point. Choosing the social model over the biomedical model and then saying, oh, now the social model, as Tom Shakespeare and others have said, on its own isn't sufficient. We need to go to a radically open-ended model. From my perspective in the disability rights movement, in our litigation and in our practice, there isn't one answer. It depends on the purpose that we're pursuing. And I think the importance of Jonas's work is to reveal the account of disability that we're operating with. It's to make us conscious. It helps to make us conscious. And I want to also, just in closing, point to this radically open-ended approach that you reference in terms of disability. And I think you suggest that it's particularly, implementing that in law, policy, practice. It's more theoretical than it may be in practice at this point. It's actually where the disability rights, parts of the disability rights movement are going. Because their instantiation of a disability identity, they are seeing increasingly as itself getting in the way of addressing patterns of marginalization, extreme marginalization, and in fact the intersecting forms of violence and disadvantage that people face. I want to point briefly, so there's some work that we're doing which is bringing a very locally based work. My colleague Doris Rajan, who came in late, is leading this work. We're bringing together women fleeing domestic violence, people with psychosocial disabilities, intellectual disabilities, immigrant and refugee, indigenous women who have been extremely marginalized, and Doris is leading this work. And one of the projects in British Columbia is led by Warriors Against Violence, which is an indigenous organization, and we were addressing violence in the indigenous community. And we're doing some focus groups with this organization, and it was to talk about the people with intellectual disabilities in the indigenous community. And Doris, in doing this focus group, observed with the leader of this, that really there's so many people with intellectual disabilities who are here and who seem to be present. And the leader of the indigenous organization, her response, as I understand, was, sure, okay, if that's what you need. If you need to name and label some people as intellectually disabled in order to justify the claims you're making, then fine. But it's strategically positioned and actually doesn't fit that discourse within that community, and actually doesn't do anything to build solidarity and depth of understanding about the sources of violence that people are facing, which is the objective of that particular body of work. So I'll just sort of conclude there by I wanted to show some very practical ways in which this revealing and opening up of the accounts of disability can help us to better understand the nature of the claims that we're making, and at the same time encourage us not to become too bound to particular accounts over others, as though we're, the radically open-ended is now the account we should all be moving. If any of us are injured in a car accident this afternoon, we want to make damn sure there's a biomedical account at St. Mike's or wherever we're going to go. We want a really clear biomedical account, and we want a really good rehab facility if we want to reclaim some of the abilities that we might have lost in that example. So I think it's about what purposes are we deploying these accounts for, and being open to the full range of accounts that may be strategically used for that purpose.
Thank you.
I'm going to step back because this man should be at the center of the table. Okay. Why don't you switch seats? You should be on sorry.
As always, I'll start with some questions of the students, but you can put up your hand and write down your name if you're not on the list of the students who sent me a question before. So some questions may have been answered, but also, if you think your question has been answered, you can say so. Hartley is the first.
Yeah.
You think it's answered? Yeah, that was the one that was answered. Okay. Anita?
I think mine was answered as well. Sorry. So, but maybe I can change it a little bit. Mine was the best fit for purpose. That was what I was left with having read the paper. So maybe I'll ask it differently. You ended with this idea of a grand unified theory, and possibly some people would prefer to have it. Like, can you think of a circumstance under which a grand... Can you
repeat the beginning of the sentence? I ended with the grand theory, you said?
Like a grand unified theory of or definition of disability. Definition we were talking. You didn't give a definition. We were talking about the possibility of that. Would there be a circumstance under which we might want a grand unified theory, and we can't live with the policy, the multiple theories? And I'm thinking of things like international conventions, where we actually have to make a decision, and it might apply to all.
So I guess so I guess what I'm trying to do in this paper mostly is to actually say that while there may be a useful commonality between a lot of those approaches that I have outlined, we could say they're all related to abnormal embodiments in some ways, and I'm just prefacing my answer to say that it would still be unlikely that a master theory or a grand theory would neatly choreograph all of those answers, and so my presentation doesn't mean that I'm asking anyone to give up on definitive, determinate accounts when that fits their goal, whatever it is, but it just circumscribes their ambition to provide an all-encompassing framework to deal with a cluster of shifting dilemmas, and I wanted to quote Herbert Hart, and moderate their, quote, romantic optimism that all the values we cherish ultimately will fit into a single system, that no one of them has to be sacrificed or compromised to accommodate another. So if you're asking me, are there circumstances where when we wouldn't need a grand theory or a theory that covers the many facets? Well, that's what I've been talking about, that the accounts that would offer that would say that the proponents of those accounts would say that it's helpful because we want to have a single definition that treats all of the aspect, but as I've outlined, it could be criticized because those definitions may still leave some things out, and they can also not be clearly prioritized between them. But it doesn't mean it's not good sometimes, and it cannot be useful. But my idea in this is just repeating that something has to be sacrificed.
Thank you.
If you want to comment on, so you should feel free as well, huh? I believe.
Yeah, let's go
Okay.
and I'll come back.
I have Gabrielle Schachter.
Oh, my question. I just was curious, as I know, I'm not sure if I picked up on this in the paper properly, but it seems like over the past 5 to 10 years that the dialogue surrounding disability and different types of disability has sort of opened up more. And I was curious if you could comment on why you think the environment has changed, or why people are more receptive to these different definitions and dealing with the polysemy.
Yeah, well, I would be curious to hear Michael's thoughts about this, because a lot of it because some of it may come from because from the academic end of things, when we're the field of philosophy of disability. When I was doing my PhD, I could count the books on one hand or two, and now they're all over. So it's been booming, and so like civil rights movement of particular times. That's why I'd be curious to hear. I mean, but we had a minister for a federal minister for disability for the first time a few years ago, and so so there is definitely a movement. I can see it happening in the academic world for sure. Disability law courses start being taught. Disability of philosophy has become a thing. And so what's your take on this?
I mean, I think there's a number of factors. There was a real, I mean, it's driven by political work of an emergent disability rights movement that kind of played on, I think, picked up the tail ends of the civil rights movement and said, and began to use that in the States, began to use that critique to challenge the kind of very fixed biomedical notion and account of disability, and began to really push for this kind of social obstacles, barrier-focused model. And that really happened in the 80s, and in Canada, the push to get disability, mental and physical disability included as prohibited grounds of discrimination in the Charter, really mobilized a national community and really positioned disability as a rights-based issue. And out of that, the disability movement actually intentionally worked to get disability studies into academic programs across the country. So there was a real push to say, you've got women's studies programs, you've got, anti-racism programs, etc. We've got to bring a critical approach to disability. And so and you reference that kind of a critical disability studies kind of perspective, which is now already 20 to 30 years old. I think in terms of popular discourse, it's really the UN Convention on the Rights of Persons with Disabilities, which embeds a very standard social model approach to disability. So I think those are some of the reasons.
Yeah. I have Nargis Fazli.
I think my question was answered.
Okay, question was answered as well. Okay. Christina.
Yeah. I think my initial question was also answered. But something that I found really interesting in the presentation was that you could trace things back to different points in history. And I'm wondering if there is a period of time in history that actually treated this having many different definitions really well that we can learn from, if you encounter that.
Well, that's an interesting but difficult question. So, well, the thing is the very notion of disability is we wouldn't even think about it. For instance, there's a quote from Lysias in my papers, which shows that impairments have always been around, different bodies have always been around, but the notion of disability associated to understandings of it in a political system that believes in individualism and rights wouldn't have been conceivable in the ancient world, for instance. So there were all kinds of different views of disabilities. So a famous outdated model called the moral model would say that if you're disabled, it's the causality of this, that's because of past sins, maybe your family or your past selves in other lives. And so you're to blame. So you should be ostracized, you should be perhaps killed so that the village wouldn't have evil spirits hanging around. So how we understand disability has had dramatic effect on the well-being of people. And in the history of disability, at some point, it has, it could be understood as from a religious point of view, instead of something evil, as people living the calvaire, in French, the calvaire is the suffering of Christ, reproducing it on earth, and therefore they would have some kind of aura about them. They could become then the object of Christian charity, but still that's not very stringent obligations of social support. So how they've been categorized throughout history has been from magical interpretations to mythical ones. So the mythical ones and the ones that are contemporary, that are familiar to our ears, date back to probably I guess I'm not a historian, and historians would put different dates, but probably dates back to the Industrial Revolution, certain forms of labor. If you're into thinking about history in terms of labor, that's one narrative, as the people being unable to partake of those new processes of labor. So how we define, and those who weren't able to participate became those problematic people that needed a name, that needed a medical diagnostic to even exist within this capitalist regime. We need a name for those people who otherwise threaten the regime. We need to put them, as Foucault said, in places isolated so that we control them, we know what's happening, we give them a name, then medicine comes in and does that in alliance with the state. That would be, instead of a materialistic or Marxist reading, it would be a Foucauldian one. So it depends how you read disability. But yeah, there are many different readings throughout history. A great book on that is Henri-Jacques Sticker, and it's the history of disability. It's been translated in English.
Any comments on? I have
just to build on this point, there is this relationship between the state, science, and ethics and how the relationship between law, science, and ethics of disability has evolved over time, and is really critical. I mean, it's in the guts of that certain definitions and formulations are created and deployed. In the area of intellectual disability, it goes back in the common law jurisdictions to a statute, 14th century statute, which was all about property rights. The king gave the king the authority to take away the property of those who were fools and idiots under the law. This is and it was the prerogative of the king to do that. But that was to protect property rights, right? To Jonas's point. And then you're going to need ways of classifying people who are on either side of that boundary. And we're still in that game today.
And at the same time, there was also the history of the special status of people who had what we now would call mental health issues.
Yeah, exactly. Yes.
Who could constitute their own community.
Right.
And
exactly.
travel around in Europe.
The ship of fools.
Nara evolution.
I think my question was answered. It was similar to Anita's and some of the comments that were made after.
Okay. Anit Latuszewska.
Mine is a little bit closer. It's been answered.
Okay.
It's been answered.
Okay.
You're
Karen-
so good,
Karen-
Jonas. See how good you are.
I think my question also answered, but I have another one. I was wondering, I guess, what we can learn out of the different conceptions of indigenous and how the state has used those terms and the word Indian as well. Legally, it's had a lot of impact. I'm wondering if anything we can learn from what the indigenous have been basically fighting for in the law when it comes to defining that group and defining the different groups within it, because it's also a polysemic kind of thing. And defining disability.
Yeah, thanks. Well, an indigenous perspective on disability, or looking at indigeneity through a disability lens would certainly be interesting. I haven't done much research on this, so I'm not well positioned to talk about this. But it is well known that there are statistically more disabilities in indigenous group and less support to indigenous communities and less support available. So there could be some interesting material for an intersectional research on what it means to have a disability and to be indigenous. There was even a student of mine once who wanted to think about this indigeneity as a disability. And so that's also an interesting...
As a legal disability, effectively.
As a kind of
Legal
disability.
disability.
Yeah. So I don't know if you have any thought about this. Or...
I mean, I think it's a really, I don't have an answer to it, but I think it's a really important, it's a really helpful question in terms of the polysemy of definition of indigeneity and how the discourse of what counts as indigenous and what doesn't, and its regulation through the Indian Act in Canada. There has been, it's a helpful example, and we're still in the politics of it, but it's an ongoing politics. Who gets to define? Who gets to name what counts as indigenous? And when you look at the intersection with disability, there's a real politics going on now in terms of counting. So we'll say, yeah, a third of people with First Nations, Indigenous have a disability. But the First Nations community have actually really challenged Stats Canada and are taking back control of the administration of population surveys related to disability, precisely because we're using a screen, a biomedical screen of disability that hasn't emerged and doesn't really fit within, who gets to count? Who gets to screen people with Indigenous people according to our biomedical accounts of disability? And is that something that Indigenous communities want to participate in? Because that enforces a naming of their people as disabled by the colonial powers categories. It opens up, you really see how, and Jonas's paper is so helpful in this, is saying, as I understand it, it's all legally and socially constructed. It doesn't take away that people experience impairment and rejection and difference and stigma in all kinds of ways. But we have to get ourselves very conscious about how the law and science and society are constructing these categories and enforcing them, right? And at any rate.
Maybe if nobody...
I have a question. When you were explaining or commenting about the latest judgment from the Supreme Court of Justice, correct me if I am wrong, but I hear that they make a differentiation between disability and impairment, correct? And then in the end you said, but in the end, impairment and disability are related to the body, to the human body. So how is that? What is then the difference between disability and impairment if both are related to the body?
So what I mean is that so I'm not exactly sure of what I said, but just to state what the law was. So the Supreme Court has recognized on different occasions an understanding of the social model of disability, or so it has been said. And so they have stated that a difference between differences that are taking place in the body as so-called true characteristics, using their language as impairment being physiological dysfunctions of some kind, something medically diagnosable, on the one hand, that are seen as somehow the true sources of the issue that claimants are dealing with. And on the other hand, socially imposed prejudices that so that the problem is born out of the prejudice. So I'm firing you because I don't like the looks of you. I haven't even, as a disabled person, I haven't even looked into whether you can carry out the job. So in the one case, there could be true, between quotes, because again, that dichotomy could be seen as simplistic by some critics, but still it is a dichotomy that is endorsed. True characteristics versus the simple prejudice that is imposed, like a myth or... And so there is a distinction between both, but both are connected to the body in the sense that in Mercier, or so in case law or in scholarship about disability, you may want to leave room to still say that because a problem in law has been to say, so what do you need to show, what do you need to prove in order to be classified as a person with a disability, and therefore, or a person with a specific kind of disability, and therefore access a certain good, fit into a certain box that the state has put there for you to have certain kinds of support that you want. So there are criteria that are set up by the state for different boxes that it creates for different categories of people with different kinds of disabilities. And so, sorry, I'm losing a bit of the thread. But yeah, so, yeah, sorry, I lost the thread of my thought. But so it's about whether you meet the criteria set up. And so just to okay, I got back on the thread. So to answer ultimately your question, which was, so aren't both of them relating to the body in some sense? Yes, they are. And people want to make sure that both of them could be considered, so that someone who wouldn't be able to show proof of one, but only of the other, would still be in, would still have access, would still fit in the box, would still have access to the support. So that would be a more generous, liberal, or open-ended, call it whatever you will, understanding of disability, to give access.
Maybe a last question, which I was going to ask, which is related to this. In the case of the Quebec Charter dealing with asymptomatic conditions, I think that's the case where Justice Leroux explicitly uses the fact that they embrace a social construction model of disability. But would you say they were really consequential in doing so? So she says that they embrace a social model of disability, but then she says at the same time there has to be some kind of basis, a physical basis.
Mm-hmm. This is in Mercier?
Would you say, does the Supreme Court approach really align with the social constructivist model that they cite? So they cite, for example, Bickenbach's work, or would you say there is some kind of a clash between the two?
Yeah. So actually, I thought about this. So although Justice Leroux claims to be incorporating the social model into Canadian law, it seems that in that case, the Supreme Court has offered a distinct discrimination model of disability, I would say. Because she doesn't require accumulation of factors typical of multidimensional models of disability. One need not be disabled by one's body and by society. Her definition is more open-ended. A handicap or a disability may be the result of a physical limitation, an ailment, a social construct, a perceived limitation, or a combination of these factors. So she refuses to provide a narrow definition of disability because what's a handicap today may not be a handicap tomorrow. Yeah. So,
yeah. She kind of puts things together.
Yeah, but at the same time, she says that having a cold right, or having blue eyes would not count as disabilities because they don't attract negative biases. So some scholars have picked up on that note, saying, well, what about people who have chronic cold? What if blue eyes became an unpleasing feature in pop culture of beauty or whatever else? And well, I agree with those scholars, but then probably she would have written something else if the culture would have been different.
So there are no further questions? Okay, yeah.
I actually have two questions. One is a very good one, I hope. I didn't really read your article or works before I came here, so I was wondering how can I access it, or maybe the slides of your presentation. And my second question could be a naive one, because I just listened to you and it was all new to me, all the different accounts. So I was wondering at any point, maybe more open-ended accounts, they stop connecting disability with body, right? So then maybe if you're a minority, like racialized minority, or like you belong to a certain group, if you're indigenous, you can be named disabled. But I'm wondering, maybe in this case, we don't need the term disability anymore. We can just say you are discriminated against, and as soon as we don't specify these different boxes, we just come to a more overarching, a different term. Maybe we don't need disability term anymore. So,
I think
please respond.
we are both excited by this question, so I will let you go first, please.
Okay, and then you can. I think, and so the legal scholar will elaborate and correct me on this. I think there's a difference between the notion of a legal disability, which is not attached to disability as we're talking about it today, but you can be legally disabled, right? Denied certain rights, and there's a way in which legal disability is used. I would be cautious about giving up on the idea that disability doesn't relate to certain bodies and certain minds. Not to instantiate it, to fix it, but that this idea, I'm going to just briefly use this. So, disability is constantly constructed. Think about this as kind of population, up to 100%. Think about this here as a 0 point, plus 1, plus 2, minus 1, minus 2. And then on any scale, walking, seeing, reasoning, any kind of function that we think about in society, we can plot the population, right? We can plot the population, and before we norm it, we just have a scattergram, right? There's just diversity. But we're always in the process of norming, right? We're going to norm it this way. We're going to norm it that way. And disability is the outlier, right? And so those bodies exist. Those minds exist. But what we create the disability in the process of norming. And norming is what goes on culturally, legally, politically. So it's all, the disablement is always going to be there because norming is so elemental to what we do. If we could get to a world where there's just the scattergram, it would be ideal. And that's what we're working towards in terms of inclusion and equality. But this norming along any function is so embedded as a way of organizing state, society, communities, our own psychology as we look out at, even in the UN Convention, the standard is people have a right to exercise legal capacity or to accessibility on an equal basis with others. There's always another, right? Disability is always the other to this more general other. So even in the core, most advanced human rights instrument we've got, there's still the norming that operates. So it's not a fixed group of bodies. It's always in relation to how we decide to do the norming. No, but Jonas had comments on this.
I would also say in response to your last question, Denise Riom, Professor Denise Riom here has written an interesting paper looking at the question about why do we have prohibited grounds of discrimination. So couldn't we just have an open concept and look at are people unjustifiable unjustifiably excluded from access to certain social goods. And why is it that we have in human rights codes prohibited grounds of discrimination, and we try to fit people within molds if you look at claims of discrimination? And if you don't fit in the molds, you can be discriminated against. So we do discriminate, we allow discrimination under the law if it doesn't fit any of the prohibited grounds of discrimination. Prohibited or enumerated, so there's an expansion of the grounds. Anyway, she has written an interesting paper. I don't remember the title, but I know that the word pigeonhole appears in the title of her paper.
Oh, okay, cool. I'll
So on, if there are no further questions, Jonas, the last word.
yeah, sure. So I'll also plug one of my ex-colleague writing on this. It's Robin Elliott and Michael Elliott, father and son, writing a prof at UBC. He wrote an article called "The Addition of an Interest-Based Route into Section 15 of the Charter." Why it's good, why we need it, how to do it. And so, and the idea is that we could choose something else to think about all the people whose different embodiment or different ways of being in the world are odd to us. Think about the main character of The Stranger in Albert Camus. There are some people who are alien and odd to us. Think about, I had a friend back in Vancouver who had chronic depression, and he said how difficult it was for him to find a job, to talk to people, to make friends. And in his case, he had depression. He had kind of a medical tag that he could invoke if he wanted to bring somebody to court. Good luck with that sometimes. But if it was just an eccentric person in some ways. So we are all trying to modulate ourselves, our behavior, to be normal enough, to be pleasing enough in our culture, meet the kind of etiquette that are unspoken. And so some people have more trouble doing that. That's a kind of social disability in a way, right? That and those things are not captured. So you may want to think, well, let's just jettison disability and deal with other things instead, other notions. And scholars have done it. Some think about stigma or vulnerability has been a big one recently, and the problem when you look at those notions, and I'm interested in that. I'm having a research project on this now, and the problem when you look at those solutions closely is that if you have too broad a notion, like say vulnerability, then you need to assess who is the truly disabled, who is the deserving poor, who is the truly deserving vulnerable, and then you recreate all the kinds of. Well, perhaps we should, to be clearer when we talk about disability, talk about racial disability and other kind and gender-based disability. So you end up recreating all the specific tools that existed. So it's so that's an interesting thought to me. Well, I guess we're out of time, but I think it's a great question. If you want to read more of the stuff I do, or it's on my SSRM page, so you can just Google me, Beaudry, Jonas-Sébastien Beaudry, and find my profile page at McGill, and there's a link to my SSRN, and many of my articles are there if you want to read. This one will be published online in the upcoming Oxford Handbook on the Philosophy of Disability. Some of the chapters are already available online. With your ID, with your University of Toronto ID, you might have access to it. Mine is being edited, but it should be there soon if you want to read this one.
So let me, before I will invite you to join me to thank our speaker and our commentator, let me announce the next seminar, Thursday, February 7th. We have Quinn Grundy, who is a professor here at the Faculty of Nursing, who will be speaking about the influence or the way in which the pharmaceutical industry is increasingly targeting nurses to shape healthcare decision making. So that's February 7th, same time, same location. So please join us then, and join me in thanking our two guests.